Hooray.
Hello, everyone. Welcome. We're just letting everyone in, and just to let you know, we've just we are recording this webinar, so it's just to let everyone know that that's what we're going to do. We're going to start promptly at 1 o'clock. Marvelous. So it's 1 o'clock. Thank you very much for coming, everyone. My name's Kerry Magnus. I am the Education and Development Lead for the BNSSG Primary Care Training Hub. You are at a webinar today, kindly hosted by ourselves, but we've also got Mr. Paul Sankey here, who is the partner at Enable Law, and he's come to talk to us about avoiding litigation. I'll hand over to Paul so he can introduce himself and talk a bit more. But just to let you know, the plan of action is for Paul to do a presentation, and there will be chance to ask questions at the end. If you've got any burning questions, please do put them in the chat, and I will gather all those questions and we'll ask them at the end of the session. So I'll hand over to you, Paul.
Thank you very much. Thank you for the invitation to speak. Just to introduce myself, my name is Paul Sankey. I'm a solicitor and partner at Enable Law. We're quite a large Southwest law firm. We're part of Put Entity. At risk of making myself the most hated person on the webinar, I'm going to tell you that my field of expertise is clinical negligence claims, and I act only for patients. So yes, I fear I've immediately lost the audience entirely there, but I think it's quite useful for you to hear from somebody who brings a patient perspective. The other thing I do actually do quite a lot of education for medical professionals as well. So I do some training for people who want to be medical expert witnesses, and our system is really reliant on expert witnesses. I also do quite a lot of training on issues like doctors' duties or medical professionals' duties in advising patients and obtaining their consent to treatment and other sort of medico-legal issues. So that's a particular interest of mine. And we act for patients. We do try and engage really constructively with health professionals because, as well as being lawyers, we're also patients ourselves, and we really value the NHS and the medical services that you provide. I'm going to share my screen. This is going to work all right. Has that come up?
Yeah, that's brilliant. Thank you.
Good. All right. Okay. So where we're going today, we're going to look at the claims landscape for really how many clinical negligence claims there are, how big a problem this is. We're going to look at some legal stuff, medical professionals' duties to patients when it comes to treatment, and advice and consent, and they're quite difficult. It's quite different, those two areas. We're going to look at when a mistake, something that goes wrong, can equate to a claim. Because lots of things go wrong, but that doesn't necessarily mean they bring claims. We're going to look at why people bring claims, and this is really, really important, I think, for you, because if you understand why people bring claims, there's a lot you can do to avoid it happening. I'm going to give you some tips on responding to. That should actually have said complaints rather than claims. Tips on responding, and a little bit on making good notes. Sorry, I just pressed the next slide a bit too quickly there. So the first one really is about the landscape. So how many medical accidents are there in a year? Each year, how many things go wrong? Well, the answer is we haven't got a clue because nobody's really studied it. There was a study back in 2000, so this is an awful long time ago, 2000, which concluded that there were probably around about 850,000 mistakes being made in NHS trusts. So this isn't GPs or allied professionals. This is within trusts each year. Well, whether that's right or wrong, I mean, who knows? I suspect it's not far off, and it's probably more than that now rather than anything else. In 2018, there was a paper which suggested that 1.5% of hospital patients between 1990 and 2013 suffered harm from adverse incidents. Now looks like a pretty big number. The harm wasn't necessarily significant harm, it was just any harm. So it might have been fairly minor things alongside fairly major things. And it concluded that 0.1% of adverse incidents, so 1 in 1,000 incidents, contributed to someone's death. So that's quite an alarming statistic. Although when you put it into perspective, there's a huge amount of medical care going on. It's a hugely complicated business, as you know. It involves a lot of coordination between different people, and it involves working with enormous organisations. So there are going to be things that go wrong. I think that's just a fact of life. How many of those turn into claims? Well, there is a real perception within the medical professional that there's an absolutely huge number of claims, and I really understand the anxiety about it. If I make a mistake, the worst that happens is that somebody loses a bit of money. If you're a medical professional and you make a mistake, the worst that happens is that somebody, well, I suppose it's worse, somebody might die. So have enormous amounts of sympathy for the fact that you do enormously responsible jobs, and when things go wrong, they can have consequences that far outweigh what the consequences if I do something wrong. And there is this perception that there's a huge number of claims. I did a talk at my local GP's practice a little while ago, and I asked them to guess how many claims there were against the NHS in a year. One person guessed 400,000. The figure actually last, that should say 2021 to 2022. The figure actually was 13,500 a couple of years ago, and it really hasn't changed very much. So the overall number, when you think about the amount of medical treatment, I don't know whether you think that's a big number or a small number, but when you think about the amount of medical treatment going on in the country, and this is hospital trusts and GPs, I don't actually think that's a huge number. And if anything, it's gone down a little bit. So the previous period, it was, I think I've got my figures wrong there. I think the last statistic, the previous statistic should have been, sorry, the 13,500 should be 2022, 2023. So that had gone down a little bit from the previous year, which was 15,000. They're small numbers, but some of the awards are very large. So there are a small number of awards for babies who suffer hypoxia at birth and end up with a lifetime of disability because of cerebral palsy. Some of those claims are settling at between 20 and 30 million. So they are absolutely huge claims, and they distort the picture. It is a small number of them, but they're very, very large awards. I don't expect you to be able to read that graph, but you can see the line. I think the important thing is that you see the line. I couldn't get a clearer version of it, but that really shows how the payments on clinical negligence claims over the last few years. And what you'll see is that although there was a big rise leading up to, I think it's 2017, it's then been relatively flat since then. So the picture isn't changing. And actually the reason for the rise is nothing to do with the amount of negligence or the number of claims. It's actually a technical, it's actually for a technical reason. When the courts are awarding damages to someone for life, they're multiplying the annual loss. So supposing somebody suffers an annual loss of £200,000 and they've got a life expectancy of 40 years, you've got to multiply that £200,000 by a figure. And the figure you multiply it by, sorry, this is a bit technical, so if you want to look at your phones and check your emails, this is the moment to do it for half a minute. The figure you multiply it by has an awful lot of assumptions in, depending on interest rates and tax rates and a whole number of other factors. And the government decided to change those assumptions in 2017, and it resulted in long-term awards. So those cerebral palsy cases, instead of settling for 5 or 6 million, they were settling for 20 to 30. So that's actually why the figure's gone up. It's not gone up because there are more claims. And what you will see later in this year is that figure changing, because it's bound to change because interest rates have been so low for the last few years. And actually the value of claims is going to go down. So I think what we'll see is that graph heading back nearer to where it was before. Anyway, that's just a sort of overview of the claims landscape. And part of what I was trying to do there was reassure you that the picture probably isn't as bad as you think it is. in terms of the number of claims. And although, as I say, although the NHS is spending a huge amount on settling damages claims, a very large proportion of that is for those lifetime claims for those children born with cerebral palsy because of birth injuries. So that's the landscape. Now, what I want to look at is, I'm going to give you some legal stuff about the tort of negligence, what negligence is. So when most of us use the term negligence in everyday speak, what we mean is carelessness. That's how the Oxford Dictionary defines it. When lawyers and courts use the term, it has a very different meaning. The legal definition, an action for damages in negligence is not just about somebody being careless. And it requires three elements. So you have to have all three for there to be a successful claim. Those three elements are: there's a breach of duty. So somebody has a duty to care for someone else, which as doctors and allied professionals, you have a duty to your patients, just as I have a duty to my clients. And when I'm out on the road, I have a duty, and I'm driving, I have a duty to other road users. So there's a duty. Someone breaches their duty. That causes, there's a causal link that causes harm, and the causation is really, really important. People can make mistakes, but if they don't cause any harm, then there's no action for damages. And then the third element is the harm itself. One analyses the harm, and you have to be able to show that there's harm and put that harm into financial terms. So that's the legal definition of negligence, three aspects. And I want to look at two of those aspects, the breach of duty and the causation, with you in just a little bit more detail. So what we're going to start with is your duty as medical professionals when it comes to providing people with treatment. And you've probably heard, and the word probably sends shivers of fear down your spine, but you've probably heard of the Bolam test, which is the test of what amounts to a breach of duty when it comes to treating people. So often the best way to understand the law is to understand the cases that gave rise to it. So most of our law doesn't come from Acts of Parliament. Most of our law comes from the courts making decisions on particular cases. And often to understand a case is the best route into understanding what the law is. So I'm going to tell you about 2 or 3 cases today. And the first one is the case of John Bolam. So we go back to 1954. Televisions were in black and white, cars were in black and white, my photos were in black and white. John Bolam had bipolar disorder, and he went into his local hospital. This is what the claim is called, Bolam against Friern Hospital Management Committee. He went to his local hospital to have electroconvulsive therapy. Now, I'm a mere lawyer, so I don't really know the details of how it's done. What I understand is that you shove an electrode either side of someone's head, and I imagine there's somebody in the background with a huge lever, and someone shouts out, "Throw the switch," and they throw the switch, and electricity pulses through the patient's brain, which induces seizures, and in this case, it induced muscle contractures so violent that poor Mr. Bolam suffered a nasty fracture to his hip. I imagine him sort of flying off the table, landing on the floor, probably exaggerating a little, and lying there, still with bipolar disorder, having just gone through the experience of electroconvulsive therapy, and now also having a nasty fractured hip, and feeling that life had dealt him a rather poor hand. And he brought a claim against his local hospital trust. And with the support of medical evidence, his case was that the doctors breached their duty to me in the way they performed electroconvulsive therapy. There are 2 things they could have done to avoid injury to me. One was to strap me down, and the other was to give me a muscle relaxant injection. And if either or both of those things had been done, I wouldn't have suffered this serious injury. And his medical experts supported that and said, yes, this was a totally avoidable injury. But the hospital defended the claim, and their medical experts said, all that is true, but there are a number of us who don't like strapping people down and don't like giving them muscle relaxant injections because both entail a degree of risk. So the court heard that there were two schools of thought about how to treat people in this context. And the judge took advantage of this. Well, the judge had to formulate what the law was, what was expected here. And he set out what is now called the Bolam test of negligence. And he said, well, a doctor or a medical professional of whatever sort needs to exercise reasonable care and skill. That's a perfectly sensible test, it seems to me, that any professional should be exercising reasonable care and skill. Not the best skill, not the best care, a reasonable level of care. It's a minimum standard, the judge said. An ordinary level of skill is enough. You don't expect the gold standard of people. And he went on to say, another way of looking at this is to say that if a doctor or a medical professional does something that is accepted as proper by a responsible body practicing that discipline, so if we're looking at psychiatrists giving electroconvulsive therapy, a responsible body of psychiatrists. If we're looking at physiotherapists providing treatment, a responsible body of physiotherapists. So you insert your discipline here. If there's a reasonable body of professionals, whatever sort, who would have done it this way, the judge said that won't be negligent. So here's the judge faced with two medical experts, each saying there's a different way of doing this. And the judge says, well, in these circumstances, we're not going to adjudicate between those two bodies. We're going to accept that there are two different ways of doing things. So that's the judge's filter on it. That's the judge's way of looking at it. Says it's a two-part test, or it's two ways. The judge actually thought these are two ways of looking at the same thing. I think they're quite different, actually. I think one is about the quality of care, and the other is about a body of people and how people actually go about it. But he said, no, I don't think there's much difference in sense. It's a different way of expressing the same thought. So all you need is a responsible body to have not breached your duty. All you need is to have done things in a way that a responsible body would have done things. There's no definition of what amounts to a responsible body. It can be a minority. The courts wouldn't say, oh, it's only 5% of people who do it this way, therefore that's not responsible. A responsible body can be a tiny minority. And what the court is concerned about is to allow professionals scope to make judgment calls on difficult issues, and to recognise that different people will take different views. So when you're treating people, maybe even when you're diagnosing people, when you're treating people, you're evaluating the risks and the benefits of different approaches. And different people are going to weigh up those risks and benefits slightly differently and reach different conclusions. One way may prove with hindsight to be wrong, but the courts don't judge people by hindsight. They say, well, we look at what you knew at the time, and we accept that different people are going to weigh risks and benefits differently. And we allow for the fact that there are different schools of thought. Even more than that, the House of Lords then later said, so the House of Lords was in those days our top court, it's now the Supreme Court. The House of Lords looked at Bolam, the Bolam test later, and in this case called Maynard against West Midlands, it said, it's not enough for a judge to say, well, I've heard two schools of thought, and I think one is better than the other. As a matter of law, a judge cannot find that one of those schools of thought is negligent, provided there's a responsible body that holds to that view. So actually, although the term Bolam probably sends shivers down your spine as medical professionals, the test is designed very much to give a lot of latitude to medical professionals and to recognise that what you're doing is difficult, that you're forming judgments, that you're drawing conclusions based on limited evidence. You can't necessarily see exactly what's going on, and you're doing your best to weigh facts in a difficult situation. I need just to nuance this slightly, because in 1997, the treatment was in 1954. The case was decided in 1957. Basically, really nothing happened in the law of negligence for another 40 years. But in 1997, the court looked at this again and said, well, we need just to nuance Boland slightly, and this is the case with Bolitho. And the House of Lords clarified the Boland test, and it said that for a body of opinion to be a reasonable, responsible body of opinion, it has to be, these are the really key words, capable of withstanding logical analysis. So the court was then saying, well, the mere fact that there are two schools of thought doesn't logically mean that one school of thought must be okay. Because if one school of thought lacks any real logical basis, then we should be entitled to reject that and say that it's negligent. Now, you'll be glad to know it's very, very rare for the courts to hear evidence about what medical professionals do and say that is simply illogical. But it does happen a little bit. There are instances where practice of particular, maybe a small group of professionals, just hasn't caught up with the with changes in knowledge and changes in practice. And there are cases where, I suppose, because of groupthink, that you just carry on doing something and nobody ever really questions it. You just get used to doing it. So it is conceivable, and there are cases where you can have responsible bodies of people who are doing things that are illogical. But happily, those are relatively rare instances. And so the court nuanced the Boland test. Remember that the test is all about a responsible body of practitioners, and said, well, for a body to be responsible, they've got to be reasonable, they've got to be rational. Those three words beginning with R are sort of substituted for each other and used as without any great differentiation between them. Reasonable means responsible, means rational. I'm just going to go on now. So I've talked a little bit about medical professionals' duties when it comes to providing treatment. In my mind, medical professionals do three things, my simplified mind. You diagnose, you advise patients, and you treat. The Boland test applies to diagnosis and to treatment, but a very different test applies to advice. And this test derives from the case of Montgomery and Lanarkshire, which was a case decided by the Supreme Court in 2015, which really quite radically changed the law in the area of advice and consent. In the photograph there is Nadine Montgomery. I've actually got to know Nadine Montgomery quite a bit. We've done some talks together on consent to medical treatment and on her case, and you can see, I think from her face, she's a very positive, smiley person, and actually through her experience of taking this case all the way through the legal process to the Supreme Court, she's got so interested in law that she's now qualified and working as a solicitor in Scotland. But anyway, back in 1999, she was pregnant with her first child. That's her child there, Sam. She was at a higher risk of shoulder dystocia than average, significantly elevated risk of shoulder dystocia because of three factors. Firstly, she suffers from type 1 diabetes. Secondly, she's not very tall, she's only 5 foot high. And thirdly, she had a whopping great baby. So her baby was pretty large. And all those factors put her at risk of the birth being complicated by shoulder dystocia. Now, that entailed a bit of risk to her, a bit of risk of injury to her. It also entailed a very small statistical risk of injury to her baby, Sam.
It's interesting cases. It's how to avoid medical litigation. So there's this case now, Montgomery.
We've got somebody else. We've got somebody else speaking in the background. I don't know whether I think you need to mute your microphone.
We'll just see that now. Sorry, Paul.
That's right. That's right. Get my thinking back on track. So, okay, elevated risk of shoulder dystocia, risk to her, very small statistical risk to her baby, but a risk of a very serious injury should that transpire. And unfortunately, that's exactly what transpired. So the birth was complicated by shoulder dystocia. Sam suffered a hypoxic injury and he has cerebral palsy. She brought a case against her she brought a case against the hospital where she had her care. And what she alleged was that she was misadvised because she wasn't told of that risk. And she wasn't told that the way to avoid the risk would have been a cesarean section rather than vaginal delivery. And at trial, the obstetrician who managed her said, I didn't warn her of this risk. And I didn't suggest a cesarean section because I thought if I did, she would have chosen to have a cesarean section. It's quite shocking, really, that she deliberately didn't advise her patient of the way to avoid the risk. And the reason she didn't do that is she thought if she had suggested a cesarean section, the dean would have elected for a cesarean section. In fact, probably any mother would have selected for a cesarean section. And she said, in her words, that was not in the maternal interest. So this is a little bit shocking, I think, that 1999 isn't that long ago. You've got an obstetrician making a decision on behalf of her patient, working out what is best for the patient without consulting the patient, and forming her own view of what is in that patient's interests. Anyway, she took her case to the equivalent of the High Court in Scotland, and she lost. And the reason she lost is that the court heard evidence that there was a responsible body of obstetricians who would have done exactly as her obstetrician had done. In effect, the court applied the Bolam test. She then appealed. She went to the Court of Appeal, and she lost. And the Court of Appeal said, well, we are bound to find that the Bolam test applies to doctors' duties to advise patients. And the evidence is that a responsible body of doctors wouldn't have advised her of that risk. She then appealed to the Supreme Court, and the Supreme Court basically changed the law. And it said the Bolam test no longer applies to advice and to matters of consent. And I'm just going to run through what the Supreme Court said the law is and what your duties as medical professionals are in advising patients and obtaining their consent. So the Supreme Court said the doctor, I've put advanced practitioner in brackets, but the Supreme Court said, obviously the context was an obstetrician. The doctor is under a duty to take reasonable care. So all the courts ever want you to do is what is reasonable. So don't get over anxious about your duties here. And it's to take reasonable care to make sure that your patients are aware of any material risks. I'm going to come back to what a material risk is, as opposed to any old risk in a minute. Material risks involved in any recommended treatment. So it's perfectly appropriate to recommend one rather than another treatment. But you need to make sure that your patient knows what the risks are of that recommended treatment, but also what the risks are of the alternatives. So in other words, it's for the patient to weigh up the risks of the alternatives and decide what they want to do. It's only really the patient that can decide the significance of their risks, given that we're all different. We all live our lives differently. We have different priorities and different concerns. So the courts want you to take a very patient-centered approach to the advice you give to your patients. And I suspect that's what we've been doing anyway. Well, when is a risk a material risk? Because you only have to tell your patients about material risks. And a material risk is material if, in the circumstances of a particular case, so this is very patient specific. So I know everybody loves, or hospitals love, standard consent forms. But I really question whether that's the right approach to risk, because the courts want you to be making patient-specific decisions about what is a risk in their context. And so a risk is material if, in the circumstances of a particular case for this patient, a reasonable person, so brace yourself for this, a reasonable person in the patient's position would be likely to attach significance to the risk. What on earth does that mean? Why do lawyers make things so difficult? Let me explain what it means by telling you what it doesn't mean. So what the court could have said is a risk is a material risk if this particular patient thinks it's material. It could have taken a wholly subjective approach to risk. On the one hand, this particular patient thinks it's material, therefore it's material. That would be impossible for you, because how do you really know what's going on inside the brain of your patient? So it says, so that's one approach it could have taken. The other approach it could have taken is the entirely objective approach and said, well, a risk is material if the reasonable patient would consider it material. We're all the same, one size fits all. When you drive your car, the standard required of you as a driver is objective. It's the same standard whether you're a 17-year-old who's just passed your test or the 99-year-old who's been driving probably a little bit longer than they should have been. The court wants to avoid both those two. So it tried to find a middle position and said, well, a risk is material if a reasonable person in this patient's position would think it's significant. So you take the characteristics of your patient and then you sort of feed them through a reasonableness filter. This is avoiding an entirely subjective test, but it's trying to make it a really patient-centered test. So I hope that makes sense. I think it's less complicated than it sounds, and I think it's probably what you'll do anyway. There is an or, and it's or the doctor or advanced practitioner should reasonably be aware that this particular patient would attach significance to it. All that's saying is, if you know something about the patient that you wouldn't otherwise test, you take it into account. So let me just contrast your duties when it comes to treatment and advice or obtaining consent. So with treatment, it's the Bolam test. With advice, it's the Montgomery test. With treatment, it's what a responsible clinician would do. With advice, it's what a patient like this patient would want to know. The Bolam test is very much a clinician-centered test. The Montgomery test is a patient-centered test. I'm going to move on. This is a bit of a whistle-stop tour. I've said that there's three key elements of the tort of negligence, and we're looking at two. We've looked at the first one, breach of duty, and we've looked at it in the context of treatment and then advice. The second bit is that for there to be negligence in the legal sense, the breach of duty has to have caused harm. While I got a picture of a cup of tea here, because the key case on this is called Barnet and Kensington and Chelsea Hospital. And this is a case from 1968, where we've got some workmen on New Year's Eve. It always amuses me when you read this case, actually, because there's a lot it doesn't tell you. It tells you that they're not workmen, they're security guards on New Year's Eve. And they, according to the case report, they've been celebrating. Now, I don't exactly know what celebrating involves because the case doesn't tell us, but I suspect it involved a fair amount of alcohol. At some point, they have a cup of tea, and somebody thought it was a merry jape to put some arsenic in their tea. So they suddenly start to feel unwell. They start to feel a bit sick. Bear in mind, they've probably got some alcohol inside them, and they turn up at their local accident and emergency department, where reading between the lines, I think they get pretty short shrift. I think the staff in the A&E aren't very sympathetic towards them. They get short shrift and they get discharged in what was admitted to be breach of duty. And a couple of them survive, and one of them dies. And his wife brought a claim in negligence against the hospital. It was admitted that there was a breach of duty, but the medical evidence suggested that any amount of treatment wouldn't have been able to save this man's life from his arsenic poisoning. His wife felt very aggrieved and thought she was entitled to damages, but the court said, no, the test of whether there's negligence here is whether the breach of duty has caused harm. And the test is, you ask the question, but for, what would have happened but for the negligence? If but for the breach of duty, if but for the breach of duty, the outcome would have been exactly the same. There's no claim here. And in this case, treatment wouldn't have saved him. So the claim fails because it fails that very simple but for test. So I spent quite a lot of time explaining to you the test of breach of duty in treatment and advice cases. When it comes to asking what the test is as to whether a breach of duty has caused harm. It's really conceptually very simple. You just ask the but-for question. You ask what would have happened but for the breach of duty. And I actually, as a lawyer acting for patients, I spend more time on causation than breach of duty, because often breach of duty is, not always, but it's often relatively straightforward. But often showing whether something has caused harm is really hard. I dealt with a lot of cancer cases over the years, people whose diagnosis of cancer has been delayed over quite a long period of time. And the issue is, well, what would have happened but for the negligence? And it's really complex. Sometimes no amount of treatment would have saved someone's life. Cancer is really aggressive. And although there's a very clear breach of duty, there's no amount of treatment that is going to save their life. Sometimes cancers are relatively slow developing. I was going to say benign probably isn't the word, but relatively slow developing. And, people can withstand quite long delays without harm being caused. So often I spend more of my time dealing with causation and trying to answer this but-for question, which is often a very complex one, than I do on breach of duty. So where have we got to? I've given you a bit of law. I've told you what the test is, what the courts expect of you when it comes to treating and advising patients. I've told you when a breach of duty gives rise to a claim in damages, and that's only when you can show that harm has been caused. And I want to change tack a little bit and ask why people bring claims, because the answer probably isn't obvious. The first thing that comes to your mind is probably because they want money, and that actually is wrong. And if you can understand why people bring claims, then there are some things you can do to stop them wanting to bring claims. So let's think about that for a moment. So, as you probably won't be surprised to know, the NHS has done some research, NHS Resolution, which handles legal claims on behalf of GPs now and hospital trusts, has done some research on why people bring claims. It's called Behavioural Insights Research, and they conclude that there are 3 factors which need to be present for someone to bring a claim. 2 you probably don't have control over. 1 you may have a good degree of influence over. So the first thing they need is the capability to bring a claim. That means they have to have understood what's happened and had some understanding, not necessarily what's gone wrong, but of the fact that something might have gone wrong. And a lot of people just simply don't know that. And another aspect of their capability is literacy, because bringing a clinical negligence claim, I can tell you, is a very document-heavy process, and often explaining things, trying to get clients to understand the complexities of their medical care is quite difficult. So to bring a claim, you need a degree of capability. Secondly, you need, the research says you need an opportunity, and the opportunity might involve the presence of a lawyer who's prepared to help them through the process. But there are other things. So people need prompts. By and large, people need prompts to bring claims. They're probably slower than you think to want to bring a claim. And they often bring a claim because somebody in their family or even a medical professional has prompted them. So interestingly, the NHS research was that in 30% of claims, the medical staff have in some way prompted somebody to bring a claim. And that's actually, doesn't surprise me as much as it probably surprises you. I said I do quite a lot of training for doctors, and I train expert witnesses and so forth. I get quite a few referrals from doctors who are pretty angry at what's happened to somebody. And they've given them the nudge, and they said, look, what happened to you just shouldn't have happened. And I think you need to speak to someone about it. So the nudge may come from medical staff, may come from friends or family. So that's capability, opportunity. You probably can't. I was going to add advertising. We as a firm don't advertise. I think it's pretty grubby, really. But there is a degree of advertising goes on that sort of gives people that prompt. You probably can't affect those 2 factors very much, but the third one is probably more interesting, and it's motivation. People need motivation to bring a claim. So if you understand that motivation, and if you can do something to prevent them having that motivation, you can reduce the risk of claims. So, according to the NHS research, 93% of people part of their motivation is anger and frustration. And that might be anger and frustration at the mistake, but quite often it's anger and frustration at the way their complaint has been handled. So this is something I hear time and time again. I think people are prepared to give an awful lot of latitude to people treating them. They know that you're there to treat them because you care. But when things go wrong and they feel things haven't been handled properly, that really is something that drives them into making complaints. So anger and frustration is a big factor. I mean, 93%, that's a huge proportion of people bringing claims. A lot of people are motivated by the desire to prevent the same happening from other people. And I hear this all the time. People phone me up and ask me whether they've got a claim, and they say, I'm not interested in money, but what I want is to prevent this from happening to other people. Another factor is an apology. Often what people really, really want is an apology. I know giving apologies is really painful, and it feels like it's putting you at risk because it feels like an admission of fault. But actually, what a lot of people want is an apology. Then there's investigation and explanation. People want to know that what's gone wrong is going to be investigated and that they're going to get an understanding of why it's gone wrong. And then sadly, some people just want to hold clinicians to account. I have to say, if anybody comes to me and says, I want to make sure that doctor never practices again, I give them some pretty forthright advice, because I know that nobody goes into medicine trying to hurt anybody. And then finally, 20% of people want financial compensation. Now, financial compensation is the only thing the court system can give. So I have to say, when people say to me, I'm not interested in money, what I want is to make sure this doesn't happen to anybody else. I have to say to them, look, the only thing the court system can give is the money. It may be that as a result of what you do, there'll be a greater understanding, there'll be more education, there'll be thought about how this can be avoided in the future. But the only thing the court can do for you is give you money. A few more findings. Does it surprise you? Claimants generally considered the reactions of NHS staff unsatisfactory following an incident. They felt generally that people were quite defensive, and the majority were not satisfied by the NHS complaints handling process. They felt that the communication that they received was poor. They felt that issues were inadequately addressed. And some of the language they used about the responses they received was inadequate. These are words that come up repeatedly: inadequate, inappropriate, dishonest, or incomprehensible, insincere. So the way you deal with complaints is really, really important. A few more findings. 69 to 75% rated the response to their complaints as poor or very poor. Doesn't sound like we're doing too well with the complaints. Their concerns were regarding accuracy, a lack of empathy. Writing a letter that sounds like it's written from a bureaucrat is a disaster. We apologise for the inconvenience caused. Why do people ever say things like that? Because it just comes over with such a lack of empathy. Speed of response. I have to say, if somebody complains to me about something I've done, I drop everything and respond to them straight away. I try and see them face to face. If I can't do that, I try and have a virtual face-to-face with them. If I can't do that, I have a phone call with them. I follow it up with an email or a letter. But you have to nip these things in the bud really, really quickly. And when people make a complaint and they wait weeks and weeks because it's got to be vetted by 4 or 5 different people who've all got to sign it and approve it, it just doesn't help resolve complaints. And a lack of detail in the response was another complaint. So, I mean, obvious things really about handling complaints: be prompt, be accurate, be empathetic, be open, acknowledge mistakes, don't be defensive. I think there is a sort of natural defensiveness because people fear that if they make admissions that they're going to be inviting claims. But actually, good complaint handling takes the sting out for people, and it's probably the best way of avoiding people bringing claims. I think I'm just going to. I'm going to rush through this because just a couple of other things I wanted to say, just to sort of draw some obvious conclusions from this. This is where I get really touchy-feely. I'm very uncomfortable doing this as a lawyer, but avoiding complaints. Then tips: good patient-centered communication, good active listening, expressing empathy, showing compassion. Building trust is really important. If people trust you, they're very, very unlikely to bring a claim against you. If you're not open, they won't trust you. Managing expectations. I know that's not particularly easy, but to manage people's expectations, you've got to understand what their expectations are. And then sometimes you have to redirect those expectations a little bit and tell them what they can realistically expect. And check patient understanding. I act for all sorts of people. Some people really struggle to understand the process and the advice I'm giving them. One of my little tips to myself is when I'm not sure that somebody is understanding, is to ask them to explain, to find a way of asking them to explain to me what I just explained to them, which I find quite a good technique. And then that really focuses you on what they haven't picked up. And then handling adverse incidents well, with openness and honesty, and with compassion and concern. I just want to say one more thing, and that's, and then I'm going to leave a bit of space for questions. I was asked to talk about the importance of good notes. Now, the reason for making good notes is to give your patients really good care. So the next time you see them, you have a record of what's happened, which informs your interaction with the patient and your advice and your treatment. And of course, to help the people who come after you, because somebody else may be picking up the story and they need to know what's happened. So what I don't want to say is that making notes is all about thinking about claims, because the primary reason for making notes is to give your patients good care. But in terms of claims, it is a really important safeguard to have good notes, and the courts will usually believe a detailed note. So judges spend a lot of time listening to witnesses and assessing who is right and who is wrong, not necessarily who's telling the truth and who's not, because often people think they're telling the truth, but their memories are faulty. What the courts really like is documentation that's been prepared at the time, because they're likely to assume that documentation that's prepared at the time is correct, and particularly when it's being prepared for some purpose other than for litigation, which your medical notes are. So a detailed note will usually be believed. So making good notes is really important when it comes to any sort of dispute. More than that, good notes create a really good impression. So if you've written a thorough and careful and detailed note, a judge is likely to look at it and think, well, this is a really, this is a diligent, careful practitioner. And if your notes are good on one issue and there's something else in dispute, it's likely to condition the judge to thinking, well, if you were right about that and if you did a good job there, you probably did a good job here as well. So it has a sort of knock-on impact in a judge's assessment of your credibility. And we all realise that notes are only the tip of the iceberg, that you might have a 5-minute conversation with somebody, but there's only a note that runs to a few lines. And we know that you're not recording everything that's happened during that conversation. But the judge will assume that that note, which is the tip of the iceberg, that below it, there's a whole load of other stuff that was said and that was discussed. So it's an indication that there's been a thorough discussion here. And the other thing I'd say about notes is that it's quite helpful where you indicate your thought process. So do you remember I said that the judges really understand that you're balancing risks and benefits when it comes to treating people, and that different people will take different views, and they allow a lot of latitude for people to come to different conclusions. When you're showing something of your thought process, that really encourages the judges to think, well, you might have got it wrong with hindsight, but what you were doing is reasonable. There's a good process of reasoning there. And even if you got to the wrong place, you were doing it, you were going about your thinking in a reasonable way. And when it comes to advice to patients, it's really helpful to record something of what your patient has said. Because what the courts want to see is that you're taking into account your patient's views and your patient's priorities. So my little tip there when it comes to advice is make sure that in your note you've got something that shows that you've listened to your patient. And the final thing, I just want to explode a myth. So doctors sometimes tell me that they're told if it wasn't written, it didn't happen. And believe me, that is not the case. So quite often, I see in witness statements from doctors, they'll say, I didn't note this down, but it is my invariable practice to do X in this particular way. And that's what I would have done on this occasion. I can't remember whether I did it, but that's what I always do. And there's no reason why a judge shouldn't believe that. There are things that I do at work that I do for every client. And I've just got this pattern, I've just got this way of doing it. It is my invariable practice to do it to go through the same structure, to do it in a particular way. And that's perfectly reasonable and understandable. So I've heard it said a lot, if it wasn't written, it didn't happen. I mean, better to have it written, obviously, but don't assume that you're sunk because you didn't write it. So there we are. I've left 10 minutes, so I meant to leave 15, so I've just gone 5 minutes over time. Apologies for that. We've looked at the claims landscape. We've looked at what your duty entails when it comes to treatment and to giving advice. We've looked a little bit at the factors that drive people to bring claims, with a view particularly to you understanding what they are so that you can avoid that happening, and a little bit at note-taking. So I will stop there. I will stop screen sharing, and if anyone's got any questions, then I'm very happy to have a go at answering them.
Oh, that was brilliant. It's Kerry. Thank you so much for that. There is a question on the chat, is what is a reasonable person?
Oh, I don't know, I've never met one. I'm not asking the right person here. The law loves this concept of the reasonable person. It applies in they used to talk about the man on the Clapham omnibus. Judges who obviously come from very public schools and Oxbridge and spend their life in quadrangles. They have this hypothetical imagination that there's the man on the Clapham omnibus, who is the reasonable person. So it's this sort of legal fiction, but when it comes to medical matters, I mean, what I was saying about the duty to advise patients is that there is no such thing as a reasonable person. You have to look at this particular person and say, what are their characteristics? What are their concerns? How do they weigh the risks and benefits? And you can only do that by talking to them and asking them questions about it. And then the reasonableness comes in as a bit of a filter. Because the judges understand that this is a really difficult thing to do, that different people are going to interpret things slightly differently, and reasonable is really just a word that enables the courts to say, well, there's a range of different ways of dealing with this.
Thank you. Just a comment from Martin. And when I was on my practitioner course, one of the lecturers said that in cases where a complaint has been made, doctors are deemed competent in their assessment, and it's the lawyers who need to prove that they are not, whereas non-doctor clinicians are the opposite, and we have to prove that we are competent as we are automatically deemed not. Is this right? So there's a difference between a doctor and another healthcare professional. So whether it's a paramedic or a nurse or a pharmacist.
So I'm not quite sure the context in which people would be deemed competent or incompetent. I don't recognise that at all. So when it comes to, and bear in mind that my world is quite a limited world, so I only deal with claims for damages. When it comes to a claim, you're not actually proving that somebody is competent or incompetent. You're looking at what they did. So you're saying, is what they did in line with what a responsible practitioner would have done? So sometimes my clients will produce, I don't know, information. They'll say, well, this person has been disciplined elsewhere or has had other claims brought against them. They must be incompetent. Or they might say, I was managed by a trainee, and therefore we assume that they didn't do it properly. Well, the courts aren't interested in any of that. They simply look at the action and say, well, what was the action? Was the action the sort of thing that a reasonable practitioner would have done, or is it not? So it's not the person, it's the action.
Thank you. Shaba, you have your hand up.
Yeah, thanks ever so much. Thank you, Paul. That was, I've had some dealings with it, some emails back and forth, as you remember, but that was absolutely brilliant, and you have such clarity and really appreciate that. Just wanted to share that I teach shared decision making, which is a big part of what you're talking about, and I often encourage people to code. There's a code on EMIS for shared decision making that you can use, and it really is your get out of jail free card for managing risk and uncertainty, because if a patient has chosen an option, it empowers them and it sort of gets you off the hook a little bit. So it's a very, very good tool for navigating complaints. I'm also the complaints lead for my practice, and just wanted to pick up on a couple of things. One was the responsiveness of complaints is very, very difficult in general practice at the moment, because we're getting inundated with them, and my responsiveness has changed from 2 weeks to 4 weeks to now 8 weeks, because I can't cope, because I only have the same amount of time to do it each week, and we're getting more and more, so it's difficult. And the second thing is what's made
Can I just make a comment? Sorry,
yes,
can I just make a comment about that? I think, I mean, you probably do this, so I'm probably teaching my granny to suck eggs, but I think the important thing then is to respond immediately.
Oh yes, we do that. Yeah.
Yeah, good. Yeah.
So we have an acknowledgement letter within 48 hours, but it's the actual response.
Yeah, it's about managing expectations.
Yeah, that's right. And so the other thing that's really helped is the increase in remote consulting. So listening to the audio is the best documentation. And I often think I'd really love this if it was face to face, but I don't have that to fall back on. And I wondered whether you think that that's going to become a thing, that we start doing audio for face to face consultations. So we've actually got a live, recording of the actual consultation, so that no one can argue with that, can they?
Yeah, I mean, it would be a great shame if you changed your practice because you were worried about litigation. From my point of view as a patient, I think it'd be a great shame. I think it may be. I don't know. There are some people who want to record their consultations with doctors. I've actually had a discussion with my daughter about it, who's a GP, about whether that's okay. It does. If it's being done because the patient is mistrustful, then that's a real red flag, isn't it? If it's being done because it's difficult for patients to understand and take on board medical advice in a consultation which is short, and they want to go back and think about it, that's a great reason for doing it. I think there's some research suggesting that patients actually, even quite sort of educated patients, come out of consultations and only remember a tiny proportion of what they were told. And so I think recording consultations to empower patients to make the best decisions and to understand medical advice is really good. One of the things, sort of discussion, I'm just thinking about the discussion I had with my daughter. I think if you're going to agree with patients that they record things, I think there should be conditions under which they do that. So I think they shouldn't be permitted to go and stick it on social media, that it should only be, and I think you should say to them, if you can do that, then you're not going to be a patient in our practice anymore. I don't know whether that's okay. But yeah, sorry, that's a bit of a ramble. Have I answered your question?
Yeah, no, that's really helpful. Thank you. Thanks.
Csaba, just to confirm, you said there was a code on shared decision making on EMIS. Is that just something that people can access and use?
Yeah, like you literally type shared decision making and you have a number of options that come up without treatment plan, this, that, and I usually code it, and then I usually write, empirical antibiotics versus awaiting MSU, patient chose latter, or what have you. Yeah.
Thank you. That's really helpful. Deborah Spencer, you've got your hand up.
Well, it's really more just to sort of share something to sort of almost back up everything that Paul's just said, because I'd not been long in general practice from a banking environment where complaints were sort of like, oh, you must try and defend. And I came to general practice and worked with an amazing sort of team who were, oh no, let's look at this, let's see what's happened and let's understand and learn from it. And we did have quite a significant situation with the patient, and there was a missed opportunity. But again, I think when you talked about it, Paul, all the reasonable things were done, but it didn't mean the outcome was what we would have liked, and it certainly wasn't a great outcome for the patient, and it involved the hospital, involved a lot of people. But the reality was that sitting down, and it was a locum, by the way, so that's probably another thing to bring into the mix here, is that it was a locum GP and we treated them like they were one of our own, and the whole situation was what we would have done with anybody. And by bringing that patient and their family into the situation and having the conversations frankly, openly, it was really resolved much better. And you know, I've had worse complaints about trivial things, where it just goes on and on and on and on, versus something that was significantly clinical, and you were open and honest and specific and direct, and you took your learnings and you apologized for what happened. And you know, I got to be honest with you, I actually, and don't shoot me for this, Paul, but I did say to the gentleman, you know, if you had a car outside and you got hit by another car, you would actually go to the insurer to claim, wouldn't you? I said, so, you know, please don't treat this any differently than it would be if you had, you know, hit your car. You know, family member is probably more important than your car. But said patient refused to make a claim because of how well we dealt with the complaint. So I just think that it's worth sharing that for those people who are worried about, you know, admitting anything at all.
Thank you, Deborah. Yeah, thank you for sharing. I think that's really good sort of reflection, particularly as a team, and it's really supportive. We are at 2 o'clock. It is the end of the webinar. There is a form. It'd be great if you can fill out just in the chat. If you click on it, then you'll be able to give us some feedback. And obviously, we're happy to set up some more sessions if there's anything that we feel is appropriate. And just thanks again to Paul for the webinar today. I really appreciate it. And if there's anything else, please do get in contact with us, and we'll pop the Training Hub email in the chat function. So thank you very much. Have a great rest of the day. And see you all soon. Bye-bye.
Thank you all.